going to do is go over the review sheet for the civil liberties and civil rights. It's online with your assignment for the test. Okay, if you want to look at that. Remember that civil liberties are about the rights that given to you, the freedoms given to you in the Bill of Rights, whereas civil rights are about discrimination. Okay? One thing I'm going to tell you about discrimination that I find with a lot of students is just a little thing. Discrimination, if you're going to say somebody discriminates about somebody else, you have to use the word against, discriminate against somebody. Sometimes I have people use the word discriminate without the preposition when they have an object. If discriminate has an object, you need the preposition against, okay? I just decided to try to tell people that because I see that happen. Now, one important thing to keep in mind about the Bill of Rights, the first 10 amendments to the Constitution, is the incorporation doctrine, because they will ask you about that. I don't know why they're so stuck on it, but they will ask you about it. Okay? And the incorporation doctrine simply says that the originally federal rights in the Bill of Rights are now applicable to the states through the 14th Amendment's Due Process Clause. Okay? Not the Equal Protection Clause, the Due Process Clause. And most of the rights in the Bill of Rights have been made applicable to the states, right? The right to a jury in a civil case in the 7th Amendment has not, but almost everything else has. Right? We'll talk about a couple of them in particular as we go through. Okay, so starting with the Bill of Rights, with the First Amendment, which is chock full of good stuff, right? First, we have religion. We have 2 religion clauses. What are they? Establishment and free exercise. What is do you want to take that off, Rick? Thank you. What does the Establishment Clause say? Separation between church and state. You can't have government-sponsored religion, basically, right? Government can't favor a religion. It can't favor religion, period. All right? And to go further on the Establishment Clause, we talked about the limit test. There's a test for what can fall within the Establishment Clause and what can't. I don't think they're going to ask you about this now. I think they may think that they have taken it off the test, so I'm not sure. Some of this stuff is unclear to me because they've put some of it in the stuff that you need to know and some of it's a little fuzzy. You used to have to know it. Is the fact that they took it out a sign that you don't have to know it? Who knows? Okay? But the limit test is the thing that tells courts when something the government has done goes too far and infringes, tries to force religion on people. Okay, now we talked about several different factual circumstances, right, that where this comes up. One of them was school prayer. What case did we talk about with school prayer? Engel versus Vitale. And what does Engel versus Vitale say? They cannot make you, that you can't have school-sponsored prayer, right? They can't make you pray. They can't make you have a moment of silence if the intent is really to make you pray. Okay? You can't make them read Bible texts, right? We also talked about money given by the government to private schools, religious-based schools. Can they do that at all? Yes. Not very often, but there are some instances where they do that. And how do we decide when to do it and when not to do it? Basically, if you can tell that they're not using the money to teach religion, you might get the court to let you do it. But if the result is to teach you religion somehow, to force religion upon you, whatever, it's not going to fly. If they have to monitor it too much, for example, if you're paying a teacher salary, you can't be sure that that teacher isn't teaching religion, so that's not going to fly. Yeah.
So when the government gives these religious schools money, does it have to go through the court process, or is there only a court process when somebody complains and says, like,
Yes.
this isn't right?
Correct. You have to have somebody complain. It's like school prayer. Schools all over the place still have school prayer because nobody's complained about it. Okay, evolution. You can't stop schools from teaching evolution. That was something that people argued was a violation of the Establishment Clause. They said, you're forcing your evolution theory on me. And then there are clubs. Sometimes clubs come up if you allow students or groups to form clubs, then you have to allow all students and groups to form clubs, including the religious groups, right? And finally, you can't display a religious symbol in a public building, okay, a government building, unless you're displaying it as one among several, basically. Okay, you can't be sponsoring any particular one. But if you're celebrating culture, it's okay. There is a case, I might run it by you when we're reviewing, where the court decided it was okay to start a public meeting, like a council meeting, with prayer. They said it's cultural, it's not really religious, it's traditional, it's blah. Okay, to me, tradition is not a very good reason for things. But okay, free exercise clause. You can believe what you want. You can mostly do what you want if your religion requires it. But there are limits, as there are with all these amendments. Make sure that before you take the test, you look over some of the cases that we looked at and that are put in the slides about what people can do and can't do. It's a good way to kind of orient you, get you calibrated, so to speak. All right? Remember, yes?
We talked about before there was this religion where they had to use a certain type of drug.
Yeah.
What religion was it?
I don't remember what the religion was called. It was Native American. A Native American way of worshiping.
Do you remember what drug?
Peyote. It's called peyote. P-E-Y-O-T-E. Peyote. Kind of a weird looking plant. It's cactus. That's what it is. It's cactus. Okay, so the Supreme Court made it more possible for the government to violate free exercise rights, some people think, in the Employment Division versus Smith case. Okay, so Congress passed a law because they didn't like how far it went. And that law applies to federal cases. And in federal cases, you have to meet the strict scrutiny test if the government law violates freedom of religion. Now, have you guys looked at the chart for the scrutiny, strict scrutiny, intermediate scrutiny, etc.? Okay, do you want me to explain it a little more? Okay, so what we have is we have conflicts, right? We have a government interest, the government need to control law and order in society, and we have individual rights. Sometimes those butt up against each other. The scrutiny graph is how we handle cases when this happens, when there's a conflict between the government and some right in the Bill of Rights, usually, okay? Now, what we do is we look to see what is it that the government is trying to accomplish. What is its goal in the legislation? Is it specifically trying to hurt a religion? If that's true, they can't do it. But whatever it is, we look at it under the strict scrutiny test. We use the same test for race discrimination. And it says that if you want to have this federal law, state law or federal law, that in some way hurts somebody's ability to exercise their religion, then you have to pass the strict scrutiny test. What does that mean? It means that the government interest, the thing that they're doing that violates religion, it has to be a compelling interest. Really, really important. Okay? And the law has to be narrowly tailored to achieve that purpose, not a whole bunch of other stuff. So to give you an example, if your law, okay, is intended to prevent hallucinogenic drug use, narcotic drug use, but instead you make other drugs illegal also. And in the course of making the other drugs illegal, you violate somebody's freedom of religion rights. Okay? They're going to look to see what the government goal is what are they trying to prevent? They're trying to prevent the use of these particular drugs. Is it narrowly tailored to this? No, because it isn't limited to these particular drugs. Does that make any sense? Okay, so religion, race, strict scrutiny. Compelling interest, narrowly tailored. The next level is intermediate scrutiny. What does that apply to? Gender. Okay? If you have a federal law, or any law that purports to violate a woman's rights, that seems to violate women's rights, then you have to meet a standard that's lower. Okay, the government, it's easier for the government to violate your rights if you're a woman than if you're black. The standard is that you have to have an important government interest, not a compelling one, but an important one, lesser, right? And then the law has to be substantially related to that interest. Doesn't have to be as close as narrowly tailored, but substantially related, okay? Then the third level, the easiest level for the government to meet is the rational relationship standard, okay? That's basically for everything else, every other kind of government conflict and distinction. And that says that the law has to be reasonably related to some government interest, or some reasonable government interest, and it has to be reasonably related, okay? So it makes it a lot easier. The thing you need to know most is that this heightened strict scrutiny standard applies to race and religion, and the intermediate scrutiny applies to gender. I hope that helped a little bit. Yes?
Who is enforcing the strict scrutiny?
The courts. So when you claim that the government has violated your right, has infringed your right, you go to the court, you say they've infringed my right. And the court is going to make you show, it's going to make the government show, if you prove that it actually does hurt your religious rights, say, then the court's going to make the government show that they had a compelling interest for this law, right? And that it was narrowly tailored, or the law's going to be struck down. That's who's going to enforce it, okay? Okay. We ready to move on to speech? Expression? Okay. One of the things to remember for speech is that the most important purpose for speech in this country is political speech. What do we mean by that? We mean speech about our government, speech about our democracy, how we run our democracy. We value that sort of speech more than anything else because it's really the whole point for the First Amendment. We want the people to be able to participate in the government. Okay, that's what a democracy is about, right? Okay. Now, when you look at all these speech issues, you might keep that in mind because there are some forms of speech that we don't protect at all, and there are some forms of speech that we protect less, in part because they're not political speech. So, for example, if you look at Tinker versus Des Moines, the armband case, the black armband case, are they engaging in political speech? They were protesting the Vietnam War, right? Is that political speech? Yes. Okay, so that was probably an important purpose to the court about what they were adjudicating. They were looking at political speech. If somebody complains about speech by a kid out in the quad, okay, that's a little different, right? If they're insulting someone, we can't really keep people, well, we can on school grounds, we can keep people from insulting each other, but in other places, you're free to insult. I don't know why I went into that, but that's okay. Okay, no prior restraint. It's very, very, very difficult to convince a court to prevent publication of something before it publishes. That's prior restraint. And the case that we need to remember for this is New York Times Company versus US. And remember that I gave you this case in the packets. I forgot to put it in red in the slides. Okay? Instead, I put in red New York Times versus Sullivan. So just keep in mind that you need to know New York Times versus US. Okay? Now, what kinds of speech are not protected by the First Amendment? All right? Speech first. Speech that disturbs the public order. Remember, one of the themes in government that the College Board really emphasizes in its materials is this balance between the necessity for government to protect law and order and our right to be free of, our rights. Okay? Our right not to have those rights infringed. All right? So, when we talk about speech and speech that disturbs the public order, we're looking at this set of two things and figuring out what's more important. Okay? If you yell fire in a crowded theater that's dangerous for people, we need to stop that because we want to protect the safety of our people, right? Okay? If you use speech that provokes a clear and present danger of substantive evils, that's been interpreted differently over time. But if you do that, if it creates a problem for public order, we're going to tell you that you can't do that. Remember what Schenck was doing? Schenck versus US, do you remember what Schenck was doing? Yes, Tim? It's handing out flyers, right? And what did the flyers want? They wanted to persuade people not to register for the draft. And that was considered very dangerous because it was against the war effort. Whenever we're in war, national security is even more important than it is usually. Okay? And then the way that we basically interpret Shink now, okay, it's changed over time, but the way we basically interpret it now is that we won't put you in jail just for saying, I want you not to sign up for the draft. Okay? And I don't even think handing out flyers would be a violation. Okay? What you have to do is incite people to imminent lawless action. You have to get them to do something like riot or protest. And if you're trying to get them to do that, then there is enough for us to limit your speech. Okay, that's speech that disturbs the public order. Next, obscenity. You cannot protect obscenity. What is obscenity? Miller versus California tells us that it has to do with whether it appeals to a prurient interest in sex, whether it's patently offensive, basically, and whether it has a scientific or literary or artistic merit. Right? We balance all those things out. What you need to remember is always obscenity. Child porn, always obscenity. Okay, that's the clearest example. All right? Also remember that when we apply the Miller test, we use local standards. So you can get one result in one location and another result in a different one. Yes?
Is there any way that you can file for in appellate cases, but then if it goes to the Supreme Court, is the ruling still on the local, or is it?
Yes.
So
the local standards are basically determinations of fact, okay? And usually an appellate court looks at issues of law. They rely on the lower court to tell them what the facts were. So it's much harder to overturn a case if you think they made the wrong decision based on the facts of the case. Okay.
How do you determine the local standards?
Largely, they let the jury decide that. Okay. What the judge does is the judge instructs the jury what you need to do when you determine whether this is obscenity is to think about what the people in your town, in your area, think about this. Is to your people, does this appeal to a prurient interest in sex? To your local people, does this have artistic literary merit? Okay?
So if the majority of the jury agrees that
You need a unanimous vote, most usually. Usually. It depends upon the case. Okay? Defamation, also not covered by the First Amendment. You have libel, which is written defamation, and you have slander, which is oral defamation. Remember, there are two standards for defamation, depending on whether you sue an ordinary person or whether you sue somebody who's famous, a well-known figure. If it's just an ordinary person, you're claiming they defamed you, all you have to do is prove that they negligently defamed you. That they made a mistake, they should have paid more attention. But if it's a famous person, you have to show that you knew or should have known that the statement that was made was false. Okay? So I defame Locke after Locke has become president. Okay? And I say Locke is a liar, he's always been a liar, he always will be a liar. Now, first of all, is that a statement of fact? I never really went over this. You might be. You're saying he's a liar. What if I said he's lying now, he lied at this particular point, and he's going to lie in the future? That's closer to a factual statement. And the reason that I'm pointing this out is you can't sue somebody for defamation over an opinion. Okay? If it's their opinion, all right, you can't prove it false or not false. It has to be a statement that's provably false. That's why I say that being a true statement is a defense, right? Okay. I'm sorry. So, do you guys understand that? You understand what I mean when I say you have to prove more if the person who sues is famous, they have to make a higher burden of proof. They have a higher burden of proof than an ordinary person does. The deal is, you wanted to be famous. This is part of the price. I think that's fair. Do you think that's fair? I don't think they should be hassled like some people do, but if you're going to be famous, people are going to talk about you. False advertising probably won't be asked about, but it's also not covered by freedom of speech. You can't mislead people in your advertising. Okay. Those are the subjects that are not protected in some fashion. Okay? Another area that historically was protected less, but is protected pretty thoroughly now, is commercial speech, in other words, advertising. Okay? But it's true that we don't value it as much as political speech, right? Okay? It's regulated by the FTC. They prevent false advertising. The FCC regulates the airwaves, radio and TV. Nothing regulates print media. Campaign spending is protected under the First Amendment, remember, under Citizens United. We'll talk about that more when we review that part of it later on in our review for the AP test. And freedom of assembly. Freedom of assembly can be limited. How? Time, place, and manner. Time, place, and manner. TPM. I don't know if that helps you. You guys have little tricks you use to remember? And freedom of association just is about hanging out. Who you can hang out with. You can hang out with whoever you want to hang out with. Okay? All right. I forgot to go over symbolic speech, so we should do that. Symbolic speech is very important because it's often political, right? Example is Tinker, because wearing the armbands was symbolic. It wasn't actual words. And we don't require actual words. Free speech can protect what you're saying even if you're communicating your message through action or gesture. Another example of something that is symbolic speech is if you burn the flag for a political purpose. If you burn it just because you feel like it, I don't think it'd be okay, but if you have a political purpose. Okay, that's First Amendment. Do you have questions about that before we go on? Yes, it is a lot. It is a lot. It is a lot. You basically, yes.
Are you ever allowed to waive your First Amendment right in any instance? Or does the government require you to waive your First Amendment?
If you are employed by the government in some capacity where you have to keep secrets, you're waiving your right to speak. Okay, you agree to adhere to the designations that they give confidential information, and you agree not to disclose them outside of what you're allowed to do. That's an example. Okay? Yeah.
Isn't there like a clause, like, I know for when we were submitting like college applications or whatever, there was like a clause where it says like you waive these rights as soon as you fill out the common application. Do you guys remember what it was?
It's FERPA.
It was what?
It's a FERPA. So I think that's like pertains to how your like whether your family can access your the information about your college app.
Okay.
Yeah, something like that.
You have a question, Brian? Anything else? So, just to, First Amendment. Number one, religion, establishment, free exercise. Okay? Number two, speech. What's protected speech? What's allowed but limited? Okay? Freedom of assembly and freedom of association. Now, in some ways, the criminal defense rights are more, but the rights are simpler, I think. The first thing, though, is to talk about the Second Amendment. Two keys. First Amendment gives an individual right to own a gun. You, as an individual, have a right. Second, it's a limited right. Okay? But what the limitations are that are allowed is still being worked out. Okay? So, at times we've had background checks, at times we've had limits on assault weapons, and things like that. And Congress makes some of these laws, states make some of these laws, and judges rule on them as they come up. hard to tell you where the bright line is. Remember that Second Amendment is applicable to the states via McDonald versus Chicago. Okay, criminal defense rights. You are innocent until this country into proven guilty by a jury of your peers. Did I tell you my story about the W, the guy with the name that started with a W?
Yeah.
I just find that hilarious. Okay, search and seizure, Fourth Amendment. You are protected from unreasonable, not any, but unreasonable search and seizure. Generally, we assume that you should get a warrant for either a search or a seizure. Arrest warrants are less common than search warrants because you can also arrest with probable cause. You have to have probable cause to get a warrant. You have to have probable cause to arrest if you don't have a warrant. And that's going to get tested. It's going to get tested when you get your warrant. If you get a warrant, it's going to get tested later if you don't get a warrant. It's still going to be tested by the court.
Just to confirm that usually the probable cause has to be run through by the judge. Right?
Yes, if you're going to get a warrant, because a warrant is a court order, so you have to go to the judge. Okay? And what I'm saying is, if I'm a cop and I see somebody, I'm around school and I see a kid carrying a gun, do I have to go get a warrant to arrest the kid? No, I have probable cause now. Okay, and I'm allowed to to base my arrest on that now. Okay? Okay. Searches, remember that you have to specify when you go to the judge where it is you want to search and what it is you want to search for. And the search warrant, the court order telling you can search, is going to tell you when you can search and where you can search and what you can search for. Okay? Now, what happens if law enforcement officials do a search and the search was illegal? What can you do about it? Yeah, you can't use that evidence. And you can't use any evidence that comes from that evidence, the fruit of the poisonous tree. It's excluded. What do we call that rule? The exclusionary rule. Illegally obtained evidence can't be used against the defendant for any purpose. Okay? Also remember that our fear of terrorism affects these rights, okay, and that sometimes the government can go further than this when they suspect you of being a terrorist. They have more freedom. Now, the Fifth Amendment, the thing you really need to know for purposes of civil rights and civil liberties is the right not to incriminate yourself. We've also talked about eminent domain, right? Okay, that's also in the Fifth Amendment. But here, it's the right not to testify against yourself. You don't have to talk to police. It's not just that you don't have to testify against yourself, it's that you don't have to talk at all if you don't want to. The Sixth Amendment has the right to counsel. That was established in felony cases in Gideon versus Wainwright. There are rights for when you go to trial. Basically what we've talked about so far are rights on things that precede trial. Right? So a lot of times people avoid trial. It's very rare. Remember, people plea bargain. They exchange an agreement to plead guilty for a confession that they committed a lesser crime, usually. You also have the right to a speedy public trial, right to confront your accusers, the right to subpoena your witnesses. Make sure you just read through all this. The right to avoid that, not to be charged or tried twice for the same crime. That's the double jeopardy provision, right? Okay, habeas corpus. You guys remember what that is? If you believe that you have been detained illegally, you can go to a judge and say, let me go. Essentially what you're saying is that there's no probable cause. That there's no cause to detain me. Okay, that's what you're saying a lot of the time. Or there wasn't sufficient evidence to convict me when you convicted me. The Eighth Amendment is the death penalty amendment. It says you can't have cruel and unusual punishment. Is the death penalty cruel and unusual? According to the courts? No, it is not. There are things that are cruel and unusual. giving the death penalty to somebody who was a juvenile when they committed a crime, somebody's mentally retarded, somebody's mentally ill. Okay. You can't give the death penalty for crimes other than treason or murder. That would be cruel and unusual. The court has now ruled that lethal injection is okay. I don't think you get a question on that, but they've now ruled that that's okay. Okay, now, that's the criminal defense rights. You got them? You understand them? Okay. All right. Remember, one of the criminal defense rights in the Sixth Amendment is the right to an impartial jury. I shouldn't forget that. To an impartial adjudication. Okay. All right, now, right to privacy. Not explicit in the Constitution. It is implied in the Bill of Rights. And rights like the First Amendment and the Fourth Amendment. Okay. And it also comes through the 14th Amendment's due process clause. It's determined that we have this right because we're granted due process. And due process includes this. All right? Now, Roe versus Wade is the case you need to know that's based on the right to privacy. Roe versus Wade's way of handling abortion is not really the way we do it now, but it is the case that established the right to abortion under the right to privacy. All right? I would look at the list of things that the court has said are acceptable and not. For example, things that are acceptable, they can require you to have a waiting period before you get your abortion after you show up. They can require you to get counseling. They can require you to have certain procedures, to give the doctor information. They can require the doctor to tell you certain things, things like that. But there are limits. They cannot limit your abortion right too far, at least not so far. Questions? About the right to privacy? Civil rights. How many of you guys watched my lecture on the civil rights? Okay, if you haven't watched that, you really need to watch that. Okay, because we haven't talked about it in class. It's about discrimination. We have talked about the scrutiny standards, which relate to this. You need to know the key events in African American history. I didn't put the early events on here, but some of these events you need to understand why we have them. Like, what's Amendment 13? No slavery. What's 14? Citizenship and due process and equal protection. Three very important things, okay? Now, where did we get the 14th Amendment? Why did they feel like they needed to say that everybody born in the U.S. was a citizen? Because that's what part of the amendment says. Why did they say that? What were they trying to reverse? Had anything in our legal history said that says that some people born in the United States are not citizens? Dred Scott, right? So the 14th Amendment is largely a response to Dred Scott, to a significant extent. What's 15 say? Right to vote. Okay, what's 24 say? No poll taxes. Right? Now, do you remember the Brown versus Board of Education? What's it about? School desegregation, right? When did it take place? In the 50s, 54, I believe it was, okay? Now, that occurs in the 50s. That's the most important thing that occurs in the 50s. Then we get some valuable things in the 60s, right? We get the Civil Rights Act in 1964. What does it do? Makes discrimination illegal in public accommodations. You can't have separate bathrooms in those hotels you run. You can't have separate bathrooms in your train station or in your restaurant. Have rules that keep you from serving those people. So you know how people have, we have the right to refuse service to anybody? That's not true. You do have the right to refuse service to anybody unless it's for racial reasons, basically, or discriminatory reasons. You can't kick somebody out of your bar just because they're black. Now, do people do that? Of course they do. Because how are you going to stop them? Somebody has to complain, somebody has to sue, somebody has to do something. That's why allowing lawsuits on these matters is so important, because it helps us stop this kind of thing. Voting Rights Act, 1965, the year after the Civil Rights Act. What does it do? Tries to enforce the protections of voting. Now, we had the 14th Amendment, which says that everybody's a citizen. That should have been enough to give blacks the right to vote, right? Because citizens have the right to vote. Well, it seemed not to, so they passed the 15th Amendment, which said specifically, you have a right to vote. Did that help? Now, we still had barriers to voting. What kinds of barriers did we have to blacks voting? Kelly, what'd you say? The literacy tests, the poll taxes. What else? The grandfather clause. Do you remember what the grandfather clause is? Yeah. If you had a grandfather who could vote in some year, 1855, it's always before the Civil War, okay? And your grandfather could vote before 55, then you could get out of the literacy test. You didn't have to take it. So that allowed poor, illiterate whites to vote. Did it allow blacks to vote? No. It was a discriminatory provision because, of course, the white people had grandfathers who could vote before the Civil War, but none of the black people did, right? So the Voting Rights Act banned any barrier to blacks voting. By the way, another significant barrier was violence, the threat of violence from the KKK and organizations like that. Let's go back for a second to de jure and de facto segregation. De jure is related to law, right? You can think of jury and jurisdictional and stuff. So de jure segregation is segregation as a matter of law. There is a law there that requires it. The law says you have to have separate schools for blacks and whites. You have to have separate bathrooms. You have to have separate water fountains. You have to have separate this, that, or the other. All right? De facto segregation is not segregation that occurs because there's a law that requires it. It occurs because of the culture. So people tend to live around people like themselves, right? Okay? And this meant that we had white neighborhoods and we had black neighborhoods. And white neighborhoods made efforts to make sure they remained white. They would require you, when you bought a house in the neighborhood, to agree not to sell to anybody who wasn't white. Eventually, the Supreme Court said that was unconstitutional. But people did it. And so it maintained this separateness, right? Which was a de facto segregation. What happens if you live in different neighborhoods? Well, all the white kids go to the neighborhood school, and all the black kids go to their neighborhood school, and you have segregated schools, right? And did a law require that? No. But did it arise because of the culture and where people live? Yes. Gerrymandering, when does it occur, by the way? When does it happen, gerrymandering? When you redistrict congressional districts or state districts, state legislative districts. What does it mean? What does gerrymandering mean? Toby?
It's like redrawing the district lines so you can like win certain districts.
Yeah, to favor a race or a party, usually, right? Okay, that's gerrymandering. It's still up in the air as to whether political gerrymandering is illegal. Racial gerrymandering is definitely illegal. Okay, so we talked about other, in the lecture I talked about other minorities, because lots of other groups, Hispanic Americans, Asian Americans, gay Americans, have used techniques in the civil rights movement to help themselves.
So how is it hard to, like, wouldn't it be hard to draw restrictions on gerrymandering, especially because the census only comes out every 10 years?
Yes.
So how are they, like, keeping track of which communities are more populated with one race versus the other?
The people in wherever the state is, the people in the state are keeping watch. So there are watchdog groups, there are interest groups that are paying attention. There are media, the media pays attention, okay? All those groups are important for informing us about what's going on and then telling the government what we think should happen.
So these are kind of like the, like Friends of the Court,
Yes, yes. any way interest groups get involved in these things in any way they can. ACLU does so much stuff, so many different ways. Okay, women's rights. Don't forget about the 19th Amendment, which gives women the right to vote. The Equal Rights Amendment was not ratified. There is the Equal Pay Act, which we're still trying to enforce. Title IX is important. What is Title IX? Let me go back to the Equal Pay Act for a second. The Equal Pay Act basically says you have to give equal pay for equal work. How do businesses get around that? They give jobs different names. Alexa?
I don't know, I'm just gonna answer.
Yeah. They give a different title to the different jobs, okay? And they pay you differently depending upon what title you give it. Okay? Title IX was part of the Civil Rights Act of a different year, can't remember which year, 1970 maybe? Or the Education Act of 1970, I think it was. But it applies to education, Title IX does. Okay, funds for education. And it says you can't discriminate based on gender in education if you receive federal funds. And it says sports, too. I think it either says sports or people understood it to apply to sports. And so it created some problems because it said you had to have balance in college sports and high school sports. And we had guys playing football. You know how many people are on some college football teams? Sometimes they have like 100 people on their team. They don't all suit up, okay? But you're supposed to have opportunities for women available to the extent that you have opportunities for men that are available. So a lot of what they did under Title IX was to try to count people who's involved, how many sports are there, how many people are you serving, and it really kind of caused problems for some of the guys when they realized that women were actually going to get as many sports as they had, sometimes more because of football. Sexual harassment, there are two kinds of sexual harassment. One is called quid pro quo sexual harassment. Does anybody know what quid pro quo means? Quid pro quo basically means yes, go ahead.
So it's an exchange for an act, so like in this case, it's saying like, if you do X, Y, Z act, I will give you a promotion or something.
Yes, exactly. I will do this for you, give you a promotion, pay you more if you have sex with me. There are, by the way, one of the problems you have if you're a woman and you get promoted, you do rise in the ranks, is that there are a lot of people out there who think you slept your way up. That is a problem. Okay, not everybody who rises through the rank has slept their way up. But there's a lot of assumptions going on, especially if you're a good-looking woman. Thank you, Marilyn. And you're young. They're almost always young. I don't know whether you guys followed this stuff about the Me Too movement in the last couple of years, but there have been a lot of things about Hollywood types and political types and all sorts of types making demands like this. Now, the other type of sexual harassment is basically known as hostile environment. Okay, and it can create sexual harassment, it can create other kinds of harassment too. You're not supposed to allow, if you're a business, the creation of a hostile environment. In other words, a situation where you feel discriminated against and assaulted, basically, either verbally, not really usually physically, but verbally about something about you or whatever, okay? So that you don't feel comfortable at work, you don't feel safe. Okay, that's hostile environment sexual harassment. I don't think you're going to be asked about that either, but it's on there. Okay, final topic, affirmative action. You should have talked about this in your U.S. history class. What is affirmative action? Emily? Yeah, that's one purpose for it. Who are you helping? Who are you trying to help? Yeah, people who have been disadvantaged, okay, in some way, shape, or form, and minorities are people that usually fall into that group. So, can you have quotas? Can you say, I'm going to make sure that I have my college class this year, have this many people in it who are black? No, of course, pretty much said you can't do that. But like what Emily said, you can have other purposes for it, other valid purposes. And the one they have specifically said was valid is diversity. Okay, you could balance your college class through including different kinds of people on it. And I'll tell you, by the way, colleges consider all sorts of things when they consider diversity. They're basically looking for anybody who has something different about them. That's an advantage to you, as you probably found out in the college application process. The court has said that when you look at laws that help people of color, you have to treat them using the same legal standard as the laws that hurt people of color. Okay? So remember we said strict scrutiny applies to the laws that might hurt, might discriminate against people of color. Strict scrutiny also applies to laws that are trying to help people of color. You can't do them unless you have a compelling interest. Okay? Remember? Compelling interest.